Believe me, I'm going to catch your attention no matter what. We've talked about agencies as having lots of different roles, and the trouble that we have is figuring out how to juggle all of these balls at the same time. On one hand, agencies, I almost missed one there, let's do that. On one hand, agencies have all different kinds of powers that the federal government has, that the different branches have. On the other hand, agencies don't have very much control. They're headless. So how do we make sure in a democracy that we keep the balls up in the air and that we keep our eye on all three things that agencies do, their judicial powers, their legislative powers, and their executive power? And how do we keep apples and air and everything else that we care about safe? This is what we look at carefully when we try to understand the APA, the Administrative Procedures Act, and the Constitution. And that's what we're going to talk about next. When FDR proposed all of these different agencies in the 1930s, people got a little scared because there wasn't any idea about what the accountability would be, how all of these agencies would work and follow the rules of democratic government at the same time. And so what we see, if you look at your reading, you've got on page 146 this discussion of the Administrative Procedure Act. And the Administrative Procedure Act came about in the 1940s as a kind of universal statutory law that would teach people and teach agencies, at the very least, how they had to operate for themselves. Now, if you look at the APA, one of the things you'll find is that there are different sections on according to the different things that agencies do. So there's a section on rule making, which is essentially the legislative function of agencies, and there is a section on quasi-judicial actions that agencies can take, and there are also some other chapters in there about things that agencies can do. The APA applies to all agencies, including the EPA, the Department of Defense, and so on and so forth. It's essentially the Bible of administrative law, this title that comes from the 1940s. And so the APA is one of the first places you want to look to find out how agencies have to conduct themselves. A second place you want to look is obviously the Constitution. Agencies cannot do anything that is not allowed in the Constitution. And so you have to make sure, for instance, that they're not taking away power that can't be given away by Congress or the executive or courts. Another limitation are the statutes themselves. Agencies, as we've discussed, are creatures of statutes, and sometimes those statutes themselves will limit agencies or present rules that agencies have to follow. The Clean Air Act, for instance, delegates its power, Congress's power, to the EPA, and then gives the EPA certain rules that it has to abide by. But for our purposes, the APA is generally the area that we have to know the most. And I'm just going to concentrate, and our reading does the same, just concentrate on the part of the APA that has to do with rule making, that is, filling in the blanks of statutes. And for reasons that are explained in the book, the rule-making process that we're interested in is informal rule-making. And although we call it informal, it really isn't all that informal, as you'll find out. In fact, there are lots of hoops and lots of procedural safeguards. So, yeah, it's somewhat of a misnomer, but we continue to call it informal rule-making. Now, if you look on page 146 of the APA, in the middle of the page, one of the things you'll see is that the APA requires essentially three things, and these are the things that you're going to be most interested in. One is when an agency is making a rule, it requires that agency to provide first a public notice in the Federal Register. That is, it has to inform the public every time it is thinking about making a rule and every time it is proposing a rule. All right. Second, it has to create an opportunity for the public to submit written comments about that rule. So even though agencies are in many ways creatures of expertise, they can't just do whatever they want without inviting the public to present its views. And when I say the public, that can mean industries that might be affected by the law. It might be people that might be affected by the law because of the safety standards. It might be groups like the Sierra Club or Greenpeace, or it might be people who are employees of businesses. You know, anybody who can be affected by this law has the right to submit comments. At the very least, these are comments that can be written by letter or now by email and must be considered by the agencies. The third thing that the APA requires is that there be a publication of the final rule in the Federal Register, accompanied by a concise statement for the basis of their opinion and the purpose of it. And then agencies are permitted to formulate rules through informal rulemaking unless an enabling statute requires that hearings be conducted. And so when we're talking about informal rulemaking, all of these things that I mentioned apply. The only thing you don't have to have are formal court-like hearings. But the agencies do have to allow people to submit comments, and they do have to read those comments and respond to them. Here's an example of what you can see on the Federal Register site. You can see, when you go to the Federal Register, you can see all kinds of proposed rules, advanced proposed rules, and other decisions agencies are making. If you look here, for instance, you'll go on the CFR, you can see here's the Department of Commerce considering Atlantic salmon in an endangered species status. You can see the same thing going to the EPA.gov website, although in a different form. They have a great electronic docket section, and you can see all kinds of rules by following through the different links to air, compliance, environmental information, and so on. Here's that same Atlantic salmon that you can see on the EPA website. Here's an example of another proposed rule, this one to designate habitat for the frosted flatwood salamander. And here are all the comments you can see. One comment is just a photograph that you can click, which is part of the area that one person thinks should be included in that designated habitat. Here is a full public submission by someone who wrote essentially a letter. You see the submitter's information here from Sandra Gibbons talking about her views on the designation of the habitat for the frosted flatwood salamander. And down at the bottom you can see her general comment is summarized, and then we'll see the whole thing. You see down below, the exclusion of unit and subunit A, not a good idea. And then, as you can see, you can read the whole letter. Some of these are very long. Some of them are written by lawyers and look very much like legal briefs explaining why a certain action would be considered illegal, for instance, and challengeable in court. Some of these things are literally just written on napkins or pieces of paper and sent in, written in freehand.